This gentleman, a freaking lawyer, look at his face. It looks like he's crying. He says, I don't recall sending the text of something so important as to when the two of them met. This is where, as a judge, I would be losing my mind. This judge is channeling Mr. Rogers throughout the whole case. All right, ladies and gentlemen, it gets better. Just when I thought it could not be worse. You could not see a lawyer embarrass him or herself worse than what we saw Fani Willis do a couple of days ago. That video has gone viral. Really appreciate the positive comments, especially from the lawyers out there and the people who seem to be not ideologically crazy. They just seem to be interested in this case and what it means for our country and our judicial system. Today I'm going to look at the testimony of Terrence Bradley. He's the former divorce attorney for Nathan Wade, former law partner of Nathan Wade. He was his attorney for 4 years during a divorce. And I'm going to tell you, ladies and gentlemen, it's a freaking roller coaster of ridiculousness. It's a banquet of buffoonery. And it's one of the most embarrassing things I've ever seen from so many positions in the judicial system. I think this case as it stands almost showcases the problems that exist in the system. I'm going to talk about lawyer tactics, the state of Georgia interfering with the truth-telling goal of the court system. I think the state attorneys were running absolute obstruction and conducting themselves completely inappropriately and unprofessionally. I think they know full well that this attorney, I think who will be a former attorney by the time this is done, is knowingly lying on the stand, and they're coaching him through objection. I'll take you through that. We'll look at some body language again. I know you guys love the body language stuff. I think that's fascinating. The unfortunate thing about this video is it's almost too obvious. Like any child could look at this lawyer and just go, you know, mommy, daddy, what's this guy hiding? Like it's painfully obvious. The symphony of deceit that we see here, masquerading as poor memory recall, was disturbing to me in terms of how the judge did not jump all over it. I think there's a couple of really big missed opportunities, and you're going to hear in the video one part that I think if you're a trial lawyer, you got to do this. And I think Ashley Merchant, lawyer who did a great job getting Terrence to spill some beans, made a critical error that could have changed the entire case if she would have employed this practice that I learned as a prosecutor years ago. So we're going to start off at the beginning, just give a little context, the walk-in, the atmosphere. I'm going to play shorter clips. It's not going to be 2 hours, and try and keep it around 40 minutes so I can get you the juice. And I look forward to your comments. Let's rock and roll.
Means where he would need to be recalled, and but if it is, then that is something you can take up. All right, Mr. Bradley, through his attorney, had informed me that he would be here today in person. I don't see him in the gallery. Do we know if he's out in the hallway? Okay. All right, if we could call for Mr. Bradley.
The reason why the judge is asking for Mr. Bradley, and he's surprised he's not there, is because previously during the hearing, he went missing for 4 hours. Now, I want to know why he's not in the court ready to go.
Judge, would it be permissible to...
I think
That's fine.
there's communications going on between this
All right,
guy
Mr. Bradley,
and people who
Deputy
don't
Scott will
want
swear you
him
in
to
again.
tell the truth, and we're going to get into that. But we'll just start off with a short little clip. You tell me what you see in his body language here, if he looks like he's a happy camper.
Terrence Bradley, Terrence Bradley, Bradley.
Ms. Merchant.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before.
Have you ever had a pet who was trained and made a mess in the house, and then you go looking for them and they won't make eye contact with you? Like, this guy is a lawyer who worked for Mr. Wade, who got a contract from Ms. Willis's office for $75,000. He's being called back in because he tried to hide behind privilege so they didn't have to tell the truth. In my humble opinion, somebody got to this guy. It's so clear. But he walks into the courtroom, sits down, and will not look at anybody. Like, generally, you look at the judge, you look at the lawyer, but he just sits down, turns his shoulders over, and will not make eye contact with a soul. You make your own decision, but, you know, like if you ask, your kid if they ate the cookies and you look at their eye contact, or if you ask your dog, did you make a mess? Like, this is exactly the body language that we're seeing from this individual.
Fani Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, Your Honor, based on privilege. That would be covered in the attorney-client privilege.
Okay, overruled.
I do not have knowledge of it starting or when it started.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court judge when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, I mean, you said it was magistrate court, municipal, you said magistrate court conference.
Take the marbles out of your mouth, my friend.
And then you asked another question. I said, no, municipal court, nothing else.
So we'll stop here. A couple things to pay attention to. First of all, you saw the state's attorney object. Listen for how many times this numbskull, well, I won't say he's a numbskull. It's an effective tactic. It can work with a jury. It can throw a lawyer off. I think it gets under Ashley Merchant's skin a bit and can throw her off. She's better today. But just objecting all the time on grounds that are ridiculous. This is a judge alone hearing. They call it a bench trial. It means the judge isn't going to be confused by a question that's improper like a jury was. That's why a lot of those objections exist, is to make sure a jury can't be misled. But I want you to pay attention to the nature of the objections. I want you to pay attention to, does the lawyer just say, object, this is irrelevant? Or does the lawyer say, I object, he already said that he doesn't remember this? This is a tactic, I have to admit, I've used it in the past. You can coach a witness by how you object. That happens and it pisses me off through the entire time. But what we're seeing here is a witness who's kind of coming in late. And he gets asked a very clear question. Everything he's saying there seems to be part of a plan. Now, he gets asked later, did he communicate with the lawyers to prepare for this? He says, no, I don't think they did a good job asking those questions. But my gut feel right off the back is somebody has told him that was a compound question. Because you guys may or may not know, he sent a text saying their relationship started back then, which is before when Wade and Willis said it. So he sent this lawyer a text saying when they started the relationship. They tried to hide that under privilege. The judge said there's no privilege for those texts. And so now he's in here trying to not reveal that Wade and Willis are perjuring themselves. And that long-winded, nonsensical answer appears to me to be their best strategy to deal with this.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
And I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of. And
Did you see that? He's telling him to say, I have no personal knowledge.
Refresh his recollection, and he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary. And so I would object to asked and answered and relevance at this point.
All right, perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact, potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This
You
is
may.
the text I can use.
So even though the judge might deny the objection, the lawyer could achieve the desired end state by putting in
And for
his
purposes of the
witnesses.
record, I believe, Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered.
All right.
And I'm happy to tender it.
Well, we'll just take it as it comes. Whatever you
We're at,
And if you want to tell
we're
the
at
truth,
39.
you don't ask people to show you the exact thing. You just tell the
May I
truth. You
approach
can
him?
see this guy's work in the system.
So, Terrence, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
Okay, so you don't recall. He sees a text message. Do you ask yourself, would this be high on the rating of an important case? Donald Trump is involved, right? Your former law partner is implicated in getting a contract that was self-serving. The district attorney who gave you a $75,000 contract as a divorce lawyer to help with the prosecution case, and the attorney for Trump's side calls you and you send a text about when they met a few months ago, max 6 months ago. This gentleman, a freaking lawyer, look at his face. It looks like he's crying. He would rather be, he says, I don't recall sending the text of something so important as to when the two of them met. This is where, as a judge, I would be losing my mind. This judge is channeling Mr. Rogers throughout the whole case. I don't understand why, because generally the judges that I've been in front of, when they can tell somebody's lying, get very angry at the liar and don't allow his lawyer to confuse things.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
Now he's
And when I
closing
asked
his
you
eyes and
if
squinting.
you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley allegedly gathered this from. There's been absolutely no foundation, and based on the arguments of the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right. I think that's. Go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule 621, I can impeach him with any inconsistent facts. This is an inconsistent fact. I can impeach him with any contrary facts.
Sure.
This is a
Why would
contrary
it
fact.
be a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So I
personal
think you have to lay that foundation then, so that'll be sustained.
The difficulty with being a trial lawyer, and I think it's one of the hardest jobs, because you're on your feet. You got to make audibles like a quarterback seeing a blitz. Like, you have to make audibles almost every 30 seconds in this particular case, where you're going to go. But you have to stay on the main points like a dog on a bone. And she had got an awesome position there. I asked you if it started before, and you answered in your text, absolutely. Not, I think so, but he answered in his text, absolutely. And then the tactic that the state lawyer is doing here, and this is what burns my ass as a former prosecutor, because we believe, I did that in Canada, where prosecutors are considered ministers of justice. So they're supposed to protect the system, not just win at all costs. And I know from some of the DAs I know down south that they conduct themselves similarly and honorably. This guy stands up when his client just gets hit with you said absolutely it started before, and he gives this long-winded word salad of an objection that puts words into the witness's mouth, but she forgets to go back to the text. Let's watch.
Do you remember telling me that it began?
Well, that doesn't address the.
No, not. I was just asking if you remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it, which we haven't determined whether he actually knows or how he knows.
She's a little frazzled, but she's got a great question here.
You told me. In fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you remember that?
Same objection, Your Honor.
Okay, I just want to. So before the last objection, she said, when I said, did it start before, you texted me and said, absolutely. Do you see how she's been knocked off it? And she doesn't go back. It's like, when I asked you if it started earlier than what Wade and Willis have said under sworn testimony, your response to me was absolutely via text. Is there any doubt in how you used the word absolutely, Mr. Bradley? Like, just dig down on there. But this lawyer for the state is effective at distracting her because she's upset that the objections are BS. What she doesn't understand is that the objections are a tactic that are designed to throw her off. And this is where good notes are very important. I got another great point coming up. I'm going to let it run a little bit.
This
here.
is the exact same issue, right?
Well, I'm asking if he remembers that. He hasn't answered that question yet.
Right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it. If that makes sense. I guess not.
I'm sorry. How he knows it, I'm just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I was asking if he told me that.
Sure.
That was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge. The statement condemns.
Source of his
hearsay
knowledge.
Because it's gossip and innuendo, which is what was indicated.
He's trying to tell
Well,
his
may not be
witness to
hearsay,
say
may
he
not be
was
We
gossip.
haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to figure that out.
He
before we
wants
go any further.
Bradley to
Yes.
say,
And if
"Oh,
the
I
source
knew
of
of
the
this through
information is
gossip
witness
and
who
innuendo."
testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or when it occurred. That was one of the first questions that Ms. Merchant asked.
I didn't ask when. I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay, so if the question is, when did you first get knowledge? I think we can start there.
That was the question. Yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you
Big
first
swallow,
gain knowledge? I didn't ask the
squinting
source of the
eyes,
knowledge, didn't ask you to
big
comment on the
chest
validity of the
breathing.
knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
Just for the record, I appreciate your honesty. But he said he has no personal knowledge, so it's clear he had to gain the knowledge, not from hearsay.
Oh my God.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we've got to get to. So,
I didn't want to take as much time here, but hearsay is that the court won't allow you to give evidence that another witness could give evidence of, unless it's the accused or somebody who's already testified. So I can't say my neighbor Joe told me that Fani Willis was lying. You know, the neighbor Joe has to testify to that. But this lawyer is objecting on hearsay that he knows is nonsense. You only get personal knowledge from other people or things. That's not hearsay. That's just how you get personal knowledge, right? And then you can confirm it. But this is pure distraction. I know the judge wants us to be welcome in his neighborhood, but he should be shutting down the state attorney who's getting in the path of the truth-telling process.
I apologize.
When did you first get knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
I don't know how to answer that. I mean, so
You don't know how to answer that, really, lawyer.
I can't give you a date if you're asking for a
Pass
date.
the bar.
If you're asking me how did I get the knowledge, it would have come directly from my client.
Right.
So help me understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
But I said that 5 minutes ago.
We have to make it clear.
Yes, sir.
Next question, Ms. Merchant.
So you don't know the specific date.
No.
Do you know if can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm going to object to this line of questioning as he said he does not know
Sure.
when he gained knowledge.
He doesn't know the specific date.
Fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on goalposts.
Thank you.
You know, an agent of the government shouldn't be so active in preventing a witness from telling the truth, right? Like you work for the government. You should want witnesses to tell the truth. You shouldn't want witnesses to be prevented from telling the truth by doing objections. Like this is just, I can't understand that this guy is getting away with it. Remember, he was his divorce lawyer. He was Nathan Wade's divorce lawyer for 4 years as he's going through a divorce, right? You think he doesn't know if you're law partners about the guy having a relationship with the district attorney who gave Nathan Wade a contract that amounted to almost $700,000 in billing, that Terrence Bradley got $75,000 contract to? You don't think that these two buddies, he doesn't know when the relationship started? He doesn't know what's going on behind closed doors? He's the divorce attorney. He goes, I just know about... It's an offense to everybody in the system that the judge and the state is allowing this to happen. And this lawyer, Ashley, is doing her best to uncover what is so patently obvious. And you can feel the frustrations in it. And I'll tell you how I might have done something that would have sunk this scumbag.
19, I would probably say no. I mean, I don't have anything that there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever.
So why did you say
so
absolutely
you're
before?
asking for a
That would
date.
be a question
You're
I'd
asking
ask.
for a year is still
How
a
would you
date.
know
And at
absolutely
this time,
that they
I am
started before?
telling you that I do not have the date.
Let's try this then. So you received a contract from Ms. Willis January 2021, correct?
Can I see the? Yes, I think so.
Exhibits are, I think, okay.
I think if it was from the exhibits, I think it was 21. Yes.
And I don't want to belabor the point, but you did those
Yes.
when you were here before.
Yes.
If those documents that you looked at last time
Yes.
said January 2022, that's okay.
21.
I'm sorry, 21. You're right. Thank
And
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was that we have in the record is January 25th, 2022.
So you got a
using
contract
that
from
date, at that
Fani
point,
Willis's
had they begun
office.
their romantic relationship?
Of 2022.
January 25th, 2022. 2021, I'm sorry. When you got your first contract.
Jesus, you gotta get your crap together.
I don't recall. I don't recall any specific dates.
Look at his brain working overtime. He knows that if he got a contract for $75,000 that Nathan Wade brought to him, that came from Fani Willis's office, and he's a partner with Nathan Wade, he knows it sounds ridiculous that he wouldn't know if they're in a relationship, unless Nathan Wade was completely hiding it, except he didn't say he was hiding it on his text messages. He told this lawyer on a phone call that they were in a relationship before the contract, and he's sitting here in the American justice system having been directed in how to lie to the court, and I can't believe the judge isn't losing his mind.
No, ma'am.
You remember when you got that contract, though, correct?
I remember I had the contract, yes.
And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly, it was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship, though,
I'm
correct?
going to object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing
He
specific.
doesn't remember the exact date, and I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly what he just said. This is asked and answered.
You can help
We're
people
getting to the end of
refresh their
it, so Ms.
memory
Merchant, we
by,
don't have much more
setting
to
benchmarks.
pull on here, but he answered that last question, so what's your next one?
He's got a lot to pull on.
And Judge, I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes.
You knew her through the business. So you had met her prior to your contract.
I'm going to object to relevance at this point as to why we're here today.
Sure.
Oh my God.
Judge, he doesn't remember much of anything right now, and so I'm trying to create a timeline to hopefully piece this together.
All right, well, I'm not seeing really the likelihood that that's going to have any success, I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you.
The objections rattled her, unfortunately. There was so much to work with here.
So the time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Yes.
Okay. And so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that he rarely saw them together.
See, he's feeding the witness.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong.
And why did they try to stop him?
By somebody else. That's that he claimed at the time was privilege. I found
So
that
who
it's not.
conveyed it
That's
to
what we're
him?
here to explore.
Okay.
She's trying to regroup. This is where it's hard as a trial
Do you
attorney.
remember telling me that not many people knew where they met?
I'm going to object as to relevance, as to his personal
God.
knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
No, you would say, do you remember telling me that? If you say, yes, I remember telling you that. Okay, well, where did you get that information from? He might have said, I have no personal knowledge, but if you enlighten him as to a fact that contradicts that, you can ask him to explain that contradiction. It's just unfortunate. This guy needs to be ripped apart, but he's sitting there in terror mode, hunkered down, just trying to get out of
His
there.
personal knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so unless he can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next.
him.
That would be the next question. But
Ask him how he knows it.
I first have to establish that he
The
said
judge
that.
is giving
You
her a
could go the
gift.
other way around.
Just ask him how he knows it. Watch the lawyer object to the judge's
When
question.
you told me that it started when she left the DA's office and was a judge in South Fulton, where did you gain that knowledge from?
Well, I'm going to object. It's his testimony a few
See
minutes
that?
ago is that he did not recall
Infuriating.
making that statement.
All right, I'll overrule that. Mr. Bradley, answer the question if you can.
But he gave him the answer.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
Look at that brain working.
I was speculating. I didn't have a,
What were you speculating based on, sir?
no one told me I was speculating.
No
Nobody-
one told you that?
No one told me that.
You were speculating based on things that had been told to you or things you had observed?
So I'm going to object as to the nature of this line of questioning because
Oh my
the
God.
witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible for this court.
All right, but the motivation
God.
for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge. Was this speculation, when you told me that, was that based on things that had been told to you and things that you had witnessed?
I never witnessed anything.
Okay.
So, it was speculation. I can't tell you anything specific if that's what you're asking.
Okay, I just want to drill down here a second because this wouldn't be believable in any. If this was in a movie script, to be thrown out as not possible, that a lawyer could be this ridiculous. So Ms. Merchant, the blonde lawyer, called this man, Terrence Bradley, former divorce attorney of Nathan Wade, who knew who she was representing, the other side of Nathan Wade. And this is before anybody had gotten to this guy. And he indicated that their relationship started well before what the timeline that Fani Willis and Nathan Wade have given. And so she's trying to just ask, Well, because then he says, no, I don't think that's true. I don't recall it. I don't recall telling you that. And then she's asking, well, why would you say that? And he goes, I was speculating. And then all of these objections get in her head, but we need to be able to say, what in the world could have caused you to speculate? Not why did you speculate, but you don't speculate based on nothing, right? And you're telling this lawyer that, and I learned this when I was in the prosecutor's office. Ashley was probably doing a great job to get this guy to start to turn evidence that helped. But you never interview a potential witness without a witness of your own. So she should have had somebody on the line who could hear it and testify that he said exactly that. What I do, and what's helped me in a practice, it's helped me in a case that I have going on right now, is I record conversations with people that I have conversations for my memory purposes. And in my jurisdiction, you're allowed to record conversations with other people for the purposes of your memory. And just like taking notes, a better form of taking notes. But whenever I'm talking to a police officer, or a government official, or a potential witness, I'm recording that conversation for my memory. The beauty of it is it's not admissible in court until the person denies they say it. So what I would have said, and would have been nice, did you tell this to me on the phone? And if he said, I didn't tell you this on the phone, I only sent the text, well, then you could play the tape. Then you could call a witness to say, I was there taking detailed notes of this conversation. She's in a difficult position where she's trying to impeach this guy on his credibility based on what he said to her, but she can't get in the witness box and give the evidence about what he said to her because she's the attorney on the case. So she kind of submarined herself by doing a good thing, but not having the right procedures in place. And this guy, if you look at the squinting, the human brain squints when they're trying to reduce inputs. Like if it's too bright, you squint because you want to reduce the input into your nervous system. Squinting like this guy is doing, his brain is running 1,000,000 miles a minute. So he's squinting so less data is coming in because his operating system is overloaded. And that's why he can't remember a question 5 seconds later. He is like a freaking Commodore 64 trying to play 2023 Call of Duty right now. His brain can't do it. That's why the lawyer is constantly objecting and giving him the words that he's been told somewhere, in my opinion, to repeat. And it's disgraceful.
You can't tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason to lie to me?
Big breath. Any reason to lie to me, sir?
I don't know if speculation is lying, but I'm.
Well, let me just show me where in this text it says you're speculating.
You didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here that this is speculation.
If this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of this relationship?
And I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. He's explored that. He said it's speculation, and he didn't get it from any source other than his own speculation.
Sure.
So
I think we're flushing that out, and I think it's her right.
See how the lawyer to say he didn't get it from any source other than his own speculation. You don't speculate based on just your own. You get it because you say, hey, why are those two guys leaving every night at 8:30 in the evening? And then I see them in the parking lot in the morning at 6 o'clock. Or why did I see them kind of brush each other's arms there? Or, why, like you speculate based on observations, right? And if you're a trained attorney, you don't speculate based on nothingness. You don't just assume stuff's happening. You didn't say assume. Like, she was denied going down this path. We're going to move on to another clip, but there's so much gold in this.
I'm having.
That's really just
I'm
a
going to
second.
object under 106 is the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
And I don't have, if it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But I mean, if I'm asked to qualify exactly where that's from, I would.
Okay, so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide
have,
the next step.
And that's what I was asking him. If that was something he just remembers making up. If he doesn't, then That's fine, but
She referenced text messages and started to go into her packet of papers.
Sure.
That have text
So you don't have a
messages.
text message to that?
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right, well,
And I'm-
he has now said that he has no knowledge, so on to your next
That's Mr.
question.
Wade
Okay.
there who came in
Did
so he could
Mr.
stare
Wade
at
tell you about the
Terrence.
trips that he and Miss Willis took?
No.
Do you have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
Overruled.
What the heck are you talking about?
I do now.
Okay, but you did not before this proceeding?
I did not know until you.
Somebody looks a little worried that he might be revealed as a perjurer if this guy doesn't do what he's told.
Of his divorce. I mean, not deposition, but something from his divorce.
Okay, and when you responded, doesn't surprise me, they took many trips to Florida, Texas, California. Those are your words though, right?
I'm going to object as to relevance. He said he did not know, and he actually learned from Ms. Merchant the information.
He said he learned about certain trips from Miss Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He said he
see.
had no information about any trips that Ms. Willis and Mr. Wade took. That he learned it all from Ms. Merchant. That was his testimony.
Sure.
Judge, I'm
Maybe
allowed.
the conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
And if Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. You remember that?
I don't recall that, but if I don't recall.
I don't recall as a tactic that lawyers give witnesses to avoid them being perjured, right? Look at his face. It's like he's being asked by his girlfriend, did you come home last night drunk with 2 panties in your pocket and smelling? I don't recall. Like it's unbelievable. She just gave excruciating detail about a conversation that he would recall. He said, yeah, it doesn't surprise me. They went on numerous trips. They went to California to his daughter drops. That shows that he has such knowledge of this relationship, but she can only present it to him as, did you say that to me? Because she was the only person other than him who heard it. And if it had been recorded, or if there had been another witness recording the notes, they would nail this person.
Okay. Judge, may I approach?
Sure. You may.
It's in one of the ones I gave you. Look at that. Let me know if it refreshes.
Huge link rate. Deep breath.
So when
This guy does not know how to deal with this
First, let me know if
information.
that refreshes your memory.
yes,
Okay.
yes.
So, it's true that you told me that they took many trips to Florida, correct?
Per that, yes, but one of the messages is cut off, and you asked about some other trips, and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't.
Yes.
And so that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow.
Yes, you did.
And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone, or whatever refreshes your memory, you said was after you left, after the firm was dissolved,
I'm
correct?
going to object to relevance.
Overruled.
It was after the firm, the trips that you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or
So she's
whenever
showing
you
him
found them, and I
texts of
said,
him
no, I
saying,
didn't know about those trips, so
So you believe I mentioned that it was after you left?
quite sure you have the text message, and I will refresh my memory.
If anybody
Is it
understood his
easier for
last
you to refresh your
answer, they
memory with your
should
own
put
phone
it in
or
the
with
comments.
my
'Cause
printouts of screenshots?
Well, you have the printout, so
I know,
I'll go.
but Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Well, I don't know if he's accepting your offer or not, so you're
would that be easier for you?
You can just provide the documents.
Okay. Let's see.
I have some water, Judge. Please.
Yeah, let me see what we can do.
So this is where,
Judge,
you
I'm
know,
just trying to pull out
having
all
your
the messages
exhibits
that you may need.
ready, tabbed, highlighted.
I don't really see, at some point we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had. And so if you've hit the high points of that, then I don't know what else we can cover that actually moves the needle.
What I'm concerned about here is she's made some comments, but a lawyer's questions are not evidence by themselves, right? And that's the argument I'd be making if not the other side is like, she may be asking questions that contain things that could be important, but it's not, it doesn't go in as evidence. Lawyers' questions are not evidence a judge or jury can rely upon to make a decision. Only the evidence of the person in the witness box. And so she's struggling to get the text. Now, if the texts are in, that's the evidence. And where they were good is that they've got the text into evidence. So if there's a text from Terrence Bradley that says, I said they were in a relationship well before, I said absolutely, I said they went on numerous trips, and then this bozo goes on the stand and says, I don't remember saying that, guess which evidence is preferred generally? The text, because he's admitted that they're his texts. So she doesn't really need to be trying to catch him in this catch-22 because they've already got the text and he can't explain them with anything other than, I don't recall.
I'll move on to the actual trips then. So you told me that they took many trips to Florida. That refreshed your memory. You told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
Okay, so he was asked, you told me they went on many trips, and she says, was that based on what Mr. Wade told you? And his answer is, that would have been based on knowledge from my client. He won't say Mr. Wade's name. That would have been based on information from Mr. Wade, but I can't remember whether he told me or not. Remember this for the last clip, where the other lawyer is asking him how many times he communicated with Mr. Wade about his relationship with Miss Willis.
The trips to Texas, and you're the one that typed to Texas. Was that based on your knowledge from Mr. Wade?
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
Obviously, I'm not asking.
Other than what would have been said by the client. So this is, you know, people say you can't suck and blow at one time. I've said in court a couple times. You cannot both exhale and inhale at the same time because sucking and blowing might be seen as too aggressive. He's like, they would have been based on information that came from the client, but I can't recall ever getting any information from the client that would explain why there's a text where I say that they went on a trip to California. It's mental gymnastics. It's truth being corrupted. And this guy deserves to be disbarred for this lying. But I believe somebody got to him. He's been instructed on how to answer. And he's been told that if he does something that lets these people be exposed as perjurers, he will never get another job again.
If you went on these trips, I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of
See the
any
sweat.
trip would have come from my client at the time.
So that would mean that he communicated with his client about him and Willis going on a trip.
You
Look
told
how
us
angry and
last
upset
week
he is.
that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
All right, we're going to continue with one of Trump's other lawyers, gentleman who's appearing by Zoom, much more forceful. I think you can see that the state's attorney treats him quite a bit differently. And I think the body language from Terrence Bradley here shows that he feels that he's facing a howitzer as opposed to a .22 rifle when it comes to these questions. And let's watch his body language. Particularly, I pay attention to what he's doing with the pen, what he's doing with his eyes, and what he's doing with his brain.
The extent of the ruling, the only ones that I deemed were not covered and that I'd asked about in the in-camera hearing because those are the ones that were relevant.
Little water,
were,
dry mouth, sign of nervousness.
any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
Fine, thank you, Your Honor. I understand. So, going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple yes and no.
Yes.
Okay. And
Squinting.
is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Is it your testimony under oath that with regards to
concern when the
conversations
brow
with
does
Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented Mr. Wade?
One conversation of what? I apologize.
The only thing I'm asking about is that area that the court said is not privileged, which is the relationship between Mr. Wade and Ms. Willis. You've testified that during the time you represented Mr. Wade from 2018 on, that you only had one conversation with him in reference to the relationship between Ms. Willis and Mr. Wade. Is that correct?
Yeah, I think that's fairly accurate, yes.
Fairly
Okay, so
accurate?
out of the entire time, I'm talking about could be 2018, 2019, 2020, 2021. When did you stop representing Mr. Wade?
It was a few months after I left the firm.
All right, give me the approximate time.
I left maybe June, July of 2022, maybe.
Okay, so that would suggest that for, assuming it's 2018, 2019, 2020, 2021, and half of 2022, which is in the vicinity of 4 to 4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Ms. Willis. Is that correct?
Jeopardy
I
theme.
don't recall having any other conversation with Mr. Wade about him and Miss Willis.
Is it your testimony then that you don't remember any other conversation, or there wasn't any other conversation besides the one?
I'm going to object this to ask and answer.
I think he's drilling down. I think that's a fair question overruled.
I don't recall. I would say it was the one, but I don't recall.
You testified that you did have communications with Mr. Wade about him visiting with Ms. Willis at a condo or apartment, correct?
I don't think I testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Okay, so he acknowledges that he had knowledge of it. This is logical hopscotch. He acknowledges he had knowledge about Mr. Wade visiting Ms. Willis in the condo in the context of their relationship. He acknowledges that. And he acknowledges that if he had knowledge of that, it had to come from Mr. Wade, but he doesn't recall having a conversation about it. like, you can't have it both ways. Mr. Wade must have told you about the condo. You worked in the same law firm. But remember earlier, he said that he got knowledge from his client, Mr. Wade, about the trips to California with Miss Willis from his client. So what we have now on the record is him acknowledging that he had at least 2 conversations with Mr. Wade about Ms. Willis, and he doesn't really get held accountable for that.
Do you recall any other thing at this point in time under oath that would indicate when the relationship started between Mr. Wade and Miss Willis?
I do not know when the relationship started between Mr. Wade and Miss Willis. I cannot recall that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now, okay?
Yes, sir.
Mr. Wade was hired as the special prosecutor on November 1st of 2021. You're aware of that, correct?
I have my contracts to show when I started. No one showed me the contract of when he started, but if he has a contract for November 1st of 2021, then that's correct.
If this guy wanted to enter a competition of picking fly feces out of pepper, he might win that, because none of this matters. Remember, Mr. Wade said that all of the money he was getting from this contract, he was sharing with his partners. Mr. Terrence was a partner. Do you not think Mr. Terrence would be aware of when $100,000 a year started coming into the firm, if what Mr. Wade said is true? This guy's pretending that he didn't know that Mr. Wade didn't come in and say, gentlemen, just nailed this huge contract. It's amazing for us. I'm going to get your contracts. He's been told to make the lawyers go to the documents, because the lawyers can get lost in the documents. It throws them off, and they don't ask questions as well. It's a pure tactic. But that furrow that you see in Mr. Bradley's forehead, that is a concern or grief furrow. This guy is actually sad and superbly concerned that he's going to get caught right now, and that's why his head is down. And I'd like to know in the comments, how much would any of you pay to get that doodling piece of paper? Because I'd love to see what he's drawn on that piece of paper, if it's a hangman's noose or a target or whatever the phrases are, because those doodles would be fascinating to me at auction.
All right. I'm going to suggest to you that the record will reflect that the contract between Ms. Willis and Mr. Wade was November 1st of 2021, correct? I want you just to accept that, okay? Is it your testimony that you don't know,
You can't force somebody to accept
under
it.
oath, whether or not there was a relationship between Mr. Wade and Ms. Willis before the contract?
I do not recall any dates of when the relationship started. So whether you are pinpointing a date of when his contract started or not, I'm telling you, I did not recall any specific date that he flat out said anything about a relationship with Miss Willis.
Okay.
So he's his divorce attorney. He knows the impropriety of having a relationship with Ms. Willis and being the beneficiary of a contract. He's not even saying, like, to think that I'm your divorce attorney, I'm also your friend, and I'm also a partner in a law firm, and the district attorney down the road who you've been hanging out with gives you a giant contract. You don't think, hey, what's going on here? You guys just friends? You guys bumping uglies? Like, you guys, what's going on here? Like, you would want to know, as a partner of a law firm, you would insist on knowing to protect your law firm. The law firm partners have to protect each other by making sure the contracts are above board. He would have asked 1,000%. It would be a big stake in the ground. You would know, were you in a relationship with her when this giant contract came in? Yes or no? Now, we all know that he knows. He knows that they had been in an extramarital affair before. He just doesn't want to say it. But for him to say, I don't know the exact date, I wish I could hear inside the judge's mind also to hear what he's saying, because this would infuriate 99% of the judges I know, who would just be shocked that somebody would lie like this on the stand.
Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26. okay? In Defense Exhibit 26, which I showed you last time, was 2 pages of text messages between you and Ms. Merchant, correct?
Correct.
All right. Now, the first page starts off by saying, Ms. Merchant, like, just date, don't hire him. Do you think it started before she hired him? You see that?
Yes, I see it. Yes.
And your response to that was absolutely, correct?
I'm going to object, ask and answer in cumulative.
All right. So, Mr. Sato, I do think we went through a lot of these texts.
We didn't go through this whole one.
Just a second, Mr. Sato. All right. I'm sorry, Mr. Sato. You said we didn't go through this
It would
particular
have been
one?
great if that was a
We
law
go
and order
through-
ringtone.
We stopped right there. I want to go.
I answered because this is
So
the
what
exact
is that?
language that she just stated a few minutes ago.
So you can tell this guy doesn't want to answer the question. He's like, no, Judge, I already answered this question unclearly and dishonestly. Please don't make me do it again with this attorney who's more aggressive. Like, looking at him, looking at the judge to throw him a rope. But what the judge's comments say to me is, we've already been down here. It clearly says, I absolutely believe it started before. This guy's nonsensical answers don't frickin' matter anymore. So why are we doing this? That's what I think the judge is saying. But all of us want to see Terrence here get held accountable for lying. And he's just saying, get me out of here, Judge. This sucks. I'm surprised he didn't write on his doodle pad, please get me out of here and I'll get you a contract.
You could read it back.
Okay, Mr.
In the
Sato.
record.
Are you saying both of these 2 exhibits weren't already covered by Ms. Merchant?
It was not gone, this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now move into evidence defense exhibit number 26.
All right, and I'd have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
It was.
No, it was only presented to Your Honor for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
Okay.
Ex parte means
Mr.
it's not
Merchant is
visible to the
indicating
members
that
of
it
the
was
court.
admitted.
I thought Mr. Sadow admitted it, but I'm organizing and them back in order.
These guys should
so
have
I-
bigger staffs and be way
I
more
think as soon as
organized
I
for a
sit
case this big.
The copies.
Like,
Alright.
Trump needs to increase his
Alright, so
retainer and get
defense
some
exhibits
freaking
26 and
associates
27
on here binding this
being
material so it's easy to
tendered.
find.
Well, actually, only 26 at this time,
Okay, Defense Exhibit 6. Any objection from the state?
but 26.
26.
I'm going to object as it relates to foundation
I'm gonna
and
object
authentication.
because,
It was used to, during the last hearing for the purpose
have nothing else
of
to do.
refreshing his recollection. And it's my recollection is that it didn't refresh his recollection, but I renew my objection as to asked and answered in cumulative.
Okay. As to foundation on authentication, I think Mr. Bradley has recognized them as texts that he sent and received, so
Exactly.
I think I'd overrule on that basis. Any other objections to their
You can see his pulse and his forehead
defense
going
counsel?
crazy.
And seeing none, Defense Exhibit 26 is now admitted. Mr. Sadow.
Thank you. All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton.
Your Honor, I'm going
They
to
met at,
object, asked and answered.
All right, understood, Mr. Body. I'm going to let Mr. Sadow have a few minutes on this, and we'll go from there. But
See, this is where I would jump in, and the lawyer is doing a good job, very focused on Mr. Bradley. But I would put on the record, I go, Your Honor, we have watched for the last hour and a half Mr. Abato, counsel for the state, repeatedly interfere with the witness answering questions, which is interfering with the flow of the cross-examination, which is an inherent right in our system for me to be able to aggressively cross-examine a witness whose credibility is in question. This Mr. Abato is constantly interrupting it. And then the judge says this long thing, and it prevents a lawyer from getting a flow. I would go after this lawyer on the record and said this is a deliberate tactic of the state to prevent the truth from coming out. And I would publicly embarrass the state because I know this is public TV. And so my only leverage against the state is to show that the state is a bad actor. And they're letting this guy getting away with it with his meek voice. And it's very good tactics on their part. But he should have become a focus of their anger to show how much he's interfering with Mr. Bradley testifying honestly.
Judge, I'm sorry. I did answer this. I answered it for Ms.
Understood.
Merchant. I stated that I was speculating. The judge, someone objected to the speculation, but this was the exact same language.
Well, thank you
when
for
I said
that,
that
Mr. Bradley. Mr. Sadow was asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do that. So, Mr. Sadow.
All right, I hesitate to have to start back where I was, but after the word absolutely, you, on your own, said it started when she left the DA's office and was judged in South Fulton. They met at the municipal court CLE conference.
So remember when Ms. Merchant got him to say absolutely and they didn't? So speculation is not absolutely. If you say, hey, when is the Super Bowl? And I say, well, I don't know. It's usually it's in February. So I'd say it's February 10th, 2025. I might be speculating. I might be guessing. But I'm not going to say absolutely if I'm speculating. So you have two contradictory things. He says absolutely, and then he definitively says they met when she left the DA's office. This is before she was the actual DA and went to go do a judgeship. That's when they met. That's when their relationship started. Well before when they testified. That's as clear as day on the paper. I think the judge sees that and just believes there's no way you're going to get this guy to admit it based on his demeanor today. So why are we just doing the same thing again and again?
That's what you said, correct?
That is correct.
Now, it's your testimony, at least so far, that when you, on your own, gave those two statements in the text, that you were merely speculating and did not have that knowledge from Mr. Wade. Is that your testimony under oath?
Yes, that's what I testified to. Yes, sir.
So you on your own came up with the whole notion that it started when she left the DA's office and was judged in South Fulton. That's, according to you, that's speculation on your part, correct?
Overruled. Answer the question, Mr. Bradley.
Yes, that's speculation on my part. Yes.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered your question. I was speculating to the answer. That is correct.
So maybe you can tell the court, in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton? Why would you speculate and say that in a text?
I knew they had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
I answered that I knew that.
You now,
I knew that
sir,
because
I'm asking you questions, and you are in a situation where you get to give answers.
Mm-hmm.
I'm asking you, how did you know that?
How did I know when they met?
Yeah.
Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
So
Okay,
you
well,
had
that's
more
another
than one conversation
conversation
about the relationship between Mr. Wade and Ms. Willis, because he told you where he met her.
That's
correct?
incorrect. Incorrect.
It's incorrect.
It's incorrect.
Okay. Let's go back to the exhibit.
So here is where, as I said, it's easy in hindsight to critique lawyers, but first of all, he focused on speculate, and he's right. You wouldn't speculate to a lawyer knowing what side she's on when you're discussing a motion about the Trump case. Like, it's not the time for guessing or stressing. But he's saying he speculates now, and so the lawyer is trying to nail him on his word speculation now. What I might have done is said, look, just let's back up a bit. When you were asked if the relationship started before, you said absolutely, right? And an absolute is not a speculation. So you said absolutely, and then you said when it started. So you wouldn't, what you're saying today about speculation is actually a complete lie to deceive the court. Because you would agree with me, you wouldn't say absolutely if you were speculating. No logical human would say absolutely when they're speculating, right? And that's where I would just leave it. But then when the next question that's great is, how did you know when they met? And he kind of begrudgingly admits, well, Mr. Wade told me. And he then goes, I got you. So you had more than one conversation. He goes, no, I didn't. As opposed to saying, okay, so let's just back up. You communicated to the courtroom 10 minutes ago that Mr. Wade told you about a California trip with Ms. Willis when his daughter had dropped out of school, right? So we know that's one. You communicated that he went to Ms. Willis's condo. That's two. And now you just communicated that he told you when they met. That's three. So when you just said a little while ago that you only had one conversation with him about the relationship, you lied to the court. On its face, you can't argue with that. That's all I would do because you're just trying to impeach his credibility more. He looks like a clear liar, but all the lawyers are trying to kind of score some points on TV a little bit here. I don't think it's really as important to the case anywhere near as much as just getting those texts in.
Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
I don't recall, but
Don't recall why you speculated?
I thought that it started at that time, but I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
No, that's not 100%
It's not, but the
correct.
beginning of the text message.
Yes, but what messages were before this message, before she said that?
I can't answer that question because I don't have them. All I have is what's in front of you.
Yes.
And it says that she says, do you think it started before she hired me? So you knew, as the counsel for a defendant in this case, that Ms. Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Ms. Willis, correct?
I mean, based on this, yes, I see what was asked.
And in response to that, you answered directly on your own what you now claim to be speculation, right?
That's correct.
He answered
So I ask you
absolutely.
one more time before I move to the next part of this. Why would you speculate when she was asking you a direct question about when the relationship started?
I have no answer for that.
Except for the fact that you do in fact know when it started, and you don't want to testify to that in court. That's the best explanation.
This is completely
Overruled.
argumentative.
Sit down, Mr.
That's the true explanation, because you don't want to admit it in court, correct?
No, I have no direct knowledge of when the relationship started.
Okay, there's a deep swallow, a tongue in the side. This is the first time I think we kind of get to the heart of it, is like the reason you're saying, and I think the guy has a very strong voice, the lawyer. You did say this, like it's almost kind of, it's something that I think Trump would like the way of talking, but it could be a little more clever in terms of, rather than say, why in the world would you speculate, is you just acknowledged that she asked you when the relationship started and if it started before the contract. She represents the defendant in this hearing. You're a lawyer. You're not like just somebody off the street who doesn't understand the importance of this. You're tied to it. Your answer, sir, was, absolutely I do. And then you give an exact time, date, location, and context. Sir, I'm going to put it to you. You're not speculating. You didn't speculate. You're actually right now lying. to cover up for Mr. Wade and Ms. Willis? And that's legal. And he goes, no, I'm not lying. I go, in fact, I'm going to put to you that you're lying because somebody had put pressure on you. There was somebody pressuring you to lie in order to protect them because you're the type of person who would like to tell the truth if you could, wouldn't you? Right? And then you would start to see him break open a bit because I can see in his face just before when he asked him, you're doing this because you have to do this. There was something in his face that was like, fuck, yes. Excuse my language. I know some people didn't like that I was swearing last time, but I served the military for a number of years and it comes out when I get agitated. But you can see in this guy's face that he knows that he's lying by saying, I don't recall. And when he was confronted with this very strong question, he goes, I have no independent recollection, which is lawyer speak for, I'm throwing in the towel. And you can see on his face that he knows he's actually doing what is a cool book called Watership Down. And it speaks on about rabbits. He's actually in what I call Tharn mode. And you can see this with witnesses. His body language really hasn't moved the whole time he's been in there. Sometimes people will kind of, if they're overconfident, they'll lie, they'll do all of this stuff. But when somebody is in Tharn mode, that's when a rabbit senses that there's an eagle above them and they just freeze. Even though there's a hole just over there they can run in, they believe that freezing will protect them. And so he has just stopped, hunched, and he has just been freezing, saying as little as possible, hoping that that eagle doesn't swoop down and eat him up. It is a human behavioral reaction, and let's see what comes on. This is, I think, the most powerful question so far.
I'm not going to go back through that again.
I would.
But if you didn't know, and you were asked specifically as this exhibit shows, maybe you can explain why you wouldn't say, I don't know.
Is that a question? You're asking me a question to
Oh,
answer?
yeah, that's a question there,
Definitely
lawyer
question.
dude.
State that again. I apologize.
If you're being asked, as we've just gone through with this text message from Ms. Merchant,
Yes.
as the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said in response, I don't know when it started?
I don't know why I didn't say I don't know.
Can we put that on a poster somewhere and say, I don't know why I said I didn't know? Because I think that's a new legal maxim we're gonna have to celebrate. Anyhow, there's way more. I'm not gonna take that much more of your time. He really doesn't do a lot of body language. The body language and behavior analysis that we see here is that he is in Tharn mode. He is not moving. Everything is shut down. I don't think he has a spare neuron to move his foot with what he's dealing with in his brain right now. I don't know how dark his doodles would be, but this case, I think, illustrates state attorneys getting in the way of the search for truth, which I don't respect or think is appropriate. But the objections were effective and can throw a lawyer off that doesn't have their exhibits sorted out. So always get associates. Always make sure you have all of your exhibits tabbed perfectly. The second somebody objects, boom, open, judge, bam, here we are, I'm going ahead. You can see how it can get you knocked off of the offensive, and you got to be on the offensive with these witnesses. What I would do, though, a little bit with Mr. Bradley, though, and I alluded to it a little bit if I was thinking of the strategy, is this guy's looking for a rope. Like, he's looking up at the judge, he's looking for a rope. I might have started off quite a bit softer. I might have asked him to talk about something that seems like a potential escape room. See if I can get that body language to open up a bit. Tell him he's a good person. You're the kind of person who does his best. You've been put in a difficult situation. You were a loyal partner at this law firm. You've been a good friend, right? Prior to this incident that involved Ms. Willis, you didn't have any problems before then. And I would get, so psychologically he would be like, yeah, he wants to be seen as a good person because he knows the entire country is seeing him as a liar at the moment. That would open him up. And then you could say, so the only reason you might be put in a position like this is because you kind of trusted somebody not to throw you under the bus, because you thought that it wouldn't be a big deal if you just helped somebody do something. And you can kind of get like little micro yeses. And now their body language, it's like when police officers try to break somebody and get a confession. There's a thing called a read technique they can use. You can use this in a courtroom as a lawyer, but if you go in and you just want to get the big hammer, Matlock moment, you'll never get it because they're totally hunkered down. You can't breach the defenses of somebody who's completely hunkered down, who's been instructed properly. You have to open up a gap and wiggle your way in through it. I think they could have done it. They could have done it if they coordinated a little better, the defense attorneys. I hope Mr. Rogers comes out and is scathing in his indictment of witnesses that appear to be lying, but I have no idea where this is going. The judge seems abnormally kind and gentle. I have met people who are intellectual powerhouses who can stay calm, but there is part of me who is concerned, especially after we learned last week about some involvement with Fani Willis. I'm interested in knowing how reliable this decision is going to be in terms of preserving the American democracy and its belief in the justice system. I'm going to do one on Nathan Wade. It'll be beautiful to look back on him and now see how his body language and behavior was responding now that we know about all those texts and all this other communication. I'll try and have it out next week. Until then, chat soon.